Good morning. Court is back in session. Uh, Our next case will be 23-4243. Dr. Anka Dublin-Wentz versus Conditioned Air Company of Naples, LLC, Lennox Industries, Lennox International. Judge John Starger presiding. Again, I have Judge Smith here with me, but for this case, we're joined by Judge Jennifer Swenson, who is joining us as associate judge, and she's currently a judge on the 10th Circuit. Who do we have representing the parties today?
Judge Kester for the appellant, Dr. Wentz.
Stephen Rosenmonster for the appellee.
Okay. Mr. Kester, you are recognized.
May it please the court, if I may have 5 minutes for rebuttal, use 15 minutes for my primary argument.
Okay.
Again, I represent Dr. Wentz, the appellant, and the plaintiff below. Where I'd like to begin is this court must reverse the trial court and send this back for a trial on damages because the very exclusions, waiver, limitations, defenses, or whatever we want to call them that Lennox is raising were specifically struck by the trial court in its default judgment. They were told in that default judgment that not only could they not raise those affirmative defenses, they could not argue those affirmative defenses. Lennox has not appealed that final judgment. Paragraph 7 says, Lennox affirmative defenses, as asserted in Lennox Industry Inc.'s amended answer and affirmative defenses to plaintiff's third amendment complaint filed on August 18, 2022, and Lennox International's answer and affirmative defenses filed on August 18, 2022, are hereby stricken. The asserted affirmative defenses cannot be asserted or otherwise argued during the trial. The court then said the trial would be solely on the issue of damages. And the damages would be the damages that my client, Dr. Wentz, could prove were connected to the claims that the court found liability on. Now, the court found liability on each of Dr. Wentz's claims. Note that negligence, count 6 and count 9, are tort claims. Liability was found on those tort claims. Second, breach of implied warranty of merchantability, counts 7 and 10, and breach of implied warranty of fitness, counts 8 and count 11. It's important to note that Dr. Wentz did not sue Lennox for breach of an express contract. When we start going through the cases, we can talk about the Title VII cases, the patent cases, the breach of contract cases. Dr. Wentz did not sue for breach of an express warranty, did not attach an alleged warranty or limitation of warranty to her complaint, did not have any judicial admissions saying that it applied, unlike Tri-Lady, unlike the Cessna case, which we'll talk about, absolutely did not bring that claim. Now, when we look at the affirmative defenses that were asserted and stricken by Lennox, we can look at 211, 212, 213, 215, 217 are their paragraphs at record 4683. Most notably, 217 was highlighted quite a bit, and that is 672.719 of the Florida statutes, where it says in a sale of goods context, you can use a written disclaimer or waiver of remedies and potential warranties. That is, in fact, the defense that they asserted. It's a defense they were told they cannot argue. It doesn't have anything to do with the connection of damages. I heard in the prior oral argument they were talking about the ICGM case, and in that case, the plaintiff failed to prove lost profits, and the court said, well, even though you got a sanction judgment, even though the pleadings were stricken, you still had to prove your damages.
So counsel, if I may just interrupt you real quickly here. I think both sides would probably concede that there's some case law that can be argued both directions on whether a limitation of liability in a contract in a scenario such as this is or is not an affirmative defense. You got a case in the Fifth Circuit that says that limitations of liability are affirmative defenses. And then we've got some Florida cases that clearly say the opposite. And I know you're trying to distinguish them, but the reality is that there's arguments that can be made both ways on it, based on the case law. And the argument that I think that you're presenting here to the court today, which is that because it's an affirmative defense, it was, and here's why, judges, here's why it's an affirmative defense. Therefore, it was stricken, and therefore they should not have been allowed to, win on summary judgment because of what we're asserting as an affirmative defense. And my question to you is, where was that raised in the lower court? The argument that you're raising here before us today, show me where that was raised in the lower court. Because my challenge is there's not a transcript to the motion for summary judgment hearing. So I'm kind of stuck with pleadings. So I've got to look at their motion for summary judgment, your response to the motion for summary judgment, and I have no arguments to look at. I have no transcript from the summary judgment hearing. So can you give me your best position on, Judge Smith, 6 DCA. Here's why. What we're arguing right now, our winning argument. Here's how and why it was preserved in the lower court before we got to you today.
First, if I may, you had some precatory assumptions I'd like to address. I have a threefold answer. The first answer is, if you look at Tri-Lady, the Southern District federal case, if you look at Cessna, and if you look at the Paul Gottlieb case, and we can talk about the other cases later, but if you look at the Cessna case, for example, Cessna is sued for an express warranty. They're also sued for negligence. In that case, the Third District Court of Appeal, and this is their supplemental authority filed yesterday, the Court of Appeal does not apply the limitation of damages to the professional negligence or negligence claim. What it says is the expert admitted that he wasn't a maintenance expert, and they said they failed on that proof. They also said that the affirmative defense, whether it is or is not an affirmative defense related to the express warranty claim when it's part of a case, was tried by consent, so it wasn't something the court had to address. If you look at the Paul Gottlieb case, it even says, we're assuming this needs to be an affirmative defense, especially if you're going to apply it against a tort case. But again, they're saying it's by consent. Now, if you look at the cold record, and I would submit to the court that under 1.510, a transcript of the lower court proceedings are relevant because we were not permitted to raise evidence at the hearing anyway. So if the court just goes to the cold record, which would be the motion for summary judgment, the response to the motion for summary judgment, and all of the attachments to the motion for summary judgment, including the affidavit of Reiner Wenz, our expert Basalta, our expert Mr. Kobsa, what you see was demonstrated in that response is there's a sanctions order that said they're not allowed to raise this. These are already articulated defenses. The sanction order says you cannot raise or argue these. They're actually arguing it. So that is the first primary thing. The response to the motion for summary judgment repeatedly says they've asserted as an affirmative defense. They're not allowed to argue it. They're not allowed to go forward on it. It is an affirmative defense throughout the entire response. So if we just look at the cold record, the real issue before the court probably is the waiver is Lennox did not appeal the default judgment. The default judgment says it's an affirmative defense, says they can't raise it and they can't argue it. Here at this court, they're not even appealing it. So the issue for this court is they haven't preserved saying that it somehow survives the order that specifically struck it. If they wanted to get rid of the clear...
That'd be if it's an affirmative defense, right? But I
No,
still want you to show me where, you said it's all throughout your response.
Correct.
And I don't, the arguments that you're raising today to categorize it as an affirmative defense, I don't see it. I've read through your response, and when you say it's all throughout, all the cases that you've relied upon, I don't see any of that in your response to Lennox's motion for summary judgment. So guide me as to how I'm supposed to find that this, categorizing this as an affirmative defense.
Lennox in its motion, in passing, raises Tri-Lady and raises a sentence from Tri-Lady that in Tri-Lady, it was not an affirmative defense. And in the Tri-Lady case, the company that installed the chiller, I don't think sold the chiller, by the way. They say in their brief they sold the chiller. It was $2,600 to install the chiller. And in that particular case, they were sued for that express warranty. TriLady said there's judicial admissions that those limitations apply. They were attached to the complaint and that they're not allowed to deviate from it. And that court said it's not an affirmative defense in that court's view in this context because it was literally the document that was being sued upon. Just like if we get into the statutory cases, if I'm bringing a patent case and the patent statute creates a cause of action, and the patent statute says I only get a remedy for the time period that you're on notice that I stamped the product as being patented, or if it's a Title VII case where I'm bringing a 1983 claim and it says that you're only entitled to this measure of damages, it's not an affirmative defense because it's in the actual thing that you're suing for. But if it's a medical malpractice cap like Ingram or the Wytoon case that's cited by it, or if I look at Oliver that explains the difference and String cites the difference, that is the issue. So if you look at the...
And that's a cogent argument, counsel. And what I'm asking is where is that in your response to their motion for summary judgment? How is the trial court supposed to know the arguments that you're raising before us today? How can we grade his papers, so to speak, and say he did wrong when the argument you just presented to me, which I said would concede as a cogent argument, where is that? Was that argument you just stated raised before the trial court?
I have 2 points. One, as we go through the motion for summary judgment and the response 100% quotes it as an affirmative defense, uses it as an affirmative defense, and says that they waived it. The argument in their motion for summary judgment is a mere passing reference to TriLady. They don't cite all these patent cases. They don't go through this entire analysis and say it's accepted out of the judicial default order. They get around the judicial default order, ask the court to reconsider the judicial default order. The court itself knows when you say, how could the court be on notice? There was a judge change between Judge Creer and then Judge Foster. Judge Foster entered the final default judgment. In his final default judgment, he refers to it as an affirmative defense. He strikes it as an affirmative defense. They're not allowed to argue it. Everybody's on notice what the pleadings are. So there's no way to say the trial court didn't know. So what the trial court actually says in its summary judgment order in favor of Lennox is it says it doesn't think that it can. It says the court cannot overlook the limitation of damages warranty directly inconsistent with its prior default judgment order. That's the issue that brings us here. I mean, the Cessna case wasn't cited to this court in their motion for summary judgment. It's a 2008 case. They file it as a supplemental authority in this case. But here, there is no way to read our response to the summary judgment motion without seeing affirmative defense raised over and over and over again. Our primary concern is, yes, Your Honor.
As far as that default judgment, doesn't it say that the case is going to proceed forward solely on the amount of damages the plaintiff is entitled to recover from the defendants? So doesn't that limitation on damages go to what is the plaintiff entitled to recover?
No, that relates to the connection between what damage was caused and the air conditioning system. And if you go to our negligence complaint, and we talk about how they keep trying to re-argue what it is that we're arguing, essentially, you can see both from our complaint, from the affidavits filed in response to the motion for summary judgment. Mr. Wenz, for example, his affidavit explains Lennox advertised, and he relied on the advertising information, that this variable speed, high efficiency unit would control temperature and humidity, and he was misled by that advertising. The affidavit of Craig Kobsa does 2 things, explains that this variable speed unit is not sufficient, does not work as advertised. He also, by the way, Mr. Kobsa explains in paragraph 13, where he cites to his exhibit D, the $3+ million in damages, record citation 6355, he explains the new system would be $145,000, add another $50,000 for a supplemental dehumidification system. And by the way, those are direct damages. So when we look at the court's order where it says it appears that there are no direct damages, the case law that's all been presented to this court is very clear, even on the issue of direct damages and incidental damages. And by the way, when Lennox argues in its reply brief or its answer brief that the only remedy that my client had was to file a warranty claim with them, and by not doing it, they waived it. That's a classic condition precedent. That is also a classic defense. That's not something that they could even rely on at this point either. They can't pull out that document, just like it had a jury trial waiver, just like it had an arbitration requirement, just like it waived punitive damages. Those are all waiver items. But in any event, when you look at what was attached and you look at what our claim is, they are trying to assert this exclusion as you're not allowed to bring a negligence claim. And if you can bring a negligence claim, well, then you can't have any damages for your negligence claim. And you can't have any damages because your only obligation was to file a warranty claim with us. Well, the fact is, we're saying their entire system does not do what they say it did. We're not saying we want a new piece of wire, we want a new condenser, we want a new this. There's no question that what they sold us does not do what they said, and at a minimum are direct damages as the replacement. But most importantly, they are in fact asserting it as a defense. They did assert it as an affirmative defense. They were told that they cannot argue that affirmative defense in any way. And the only issue for this court to decide is, now that we have liability, are we entitled to show what damages that were incurred as a result of the liability for the torts and the common law implied warranties that we sued for? We did not sue for express warranty, and we're not here on an express warranty. I see I have exceeded my time, and I'll save the rest for rebuttal if I may.
Thank you, counsel. Mr. Rosenwasser?
For a short person.
Sorry about that. You're recognized.
May it please the court. My name is Stephen Rosenwasser from Greenberg Trard, and I have the pleasure of representing the appellee Lennox Industries. The core question on this appeal is not whether a consequential damages bar is an affirmative defense. In fact, this court doesn't have to reach that issue at all. The actual core question before this court is whether the trial court, when exercising its discretion to fashion a sanction against Lennox, given the circumstances before it, intended to preclude and did preclude Lennox from raising the consequential damages bar at the damages phase. In fact, the appellants concede that the core issue on appeal is the interpretation and scope of the court sanctions order. And they write this on page 2 of their reply brief, quote, "The interpretation of the sanctions orders and default judgment are core issues in this appeal." The bottom line is this: within certain bounds prescribed by law, the trial court had discretion to fashion a sanction that it thought was appropriate given the conduct before it. If the trial court concluded that Lennox's conduct did not warrant a sanction that precluded it from raising the consequential damages bar at the damages phase, the trial court's opinion is easily affirmed, because there is no doubt that the warranties that the trial court found apply to this equipment, and that, by the way, that wasn't appealed. That is a non-appealed finding, that the warranties applied to this equipment have a consequential damages bar. Now, fortunately, this court doesn't have to speculate what the trial court intended to do through its sanction order. At least twice, the trial court was expressly asked, does your sanctions order bar Lennox from relying on the consequential damages bar at the damages phase? And both times the court said no. And at first it was at the summary judgment phase. At summary judgment, the appellee expressly argued that, as it is today, that the trial court's order barred Lennox from relying on the consequential damages bar. And the court acknowledges in its summary judgment order, it writes, quote, "Plaintiff asserts that the court's March 9th, 2023 sanction order controls, and defendant should not be able to assert this defense at this time." So the court recognized that was the issue before it, and the court rejected that argument. The court's summary judgment order says that the appellant still has to prove damages. As Judge Swenson pointed out, it had to show its entitlement to damages, and that nothing in the court's sanctions order changed the fact that the consequential damages bar applied to the equipment, and it barred all the damages that plaintiff sought here. But there's more. The appellant then moved for reconsideration, and on reconsideration, the appellant argued on page 23 that the consequential damage bar argument was, quote, barred by the default judgment. And the trial court rejected that again. As the Court of Appeals held in Dixon v. State, quote, it was for the trial court to interpret its own order. And what the appellant is asking this court to do is to ignore the trial court's interpretation of its own order and to come up with your own interpretation of that order. And in fact, the appellant is asking you to impose a sanction that is harsher than the one that the trial court thought was appropriate. And that creates two problems. Number one, it violates due process. But number two, this is an invitation for this court to commit the very same error that the Supreme Court of Florida found the Court of Appeals made in Harless v. Kuhn. And that's cited on page 23 of our brief. And that case is on all fours with this case. In that case, the defendant was defaulted for discovery violations. At the damages phase, the defendant sought to raise a comparative negligence defense. The plaintiff in that case, just like appellant here, said, hold on, you can't raise that as an affirmative defense. It's barred by the default judgment. And the trial court said, no, that was not the intention of my default judgment, and went ahead and allowed that defense to be raised. On appeal, the DCA reversed and said, no, the default judgment barred you from raising a comparative negligence defense, which, by the way, is clearly an affirmative defense. The Supreme Court of Florida came back in afterward, and this is at 403 Southern 2nd 423, and reversed the DCA. It said, quote, a trial judge has a wide range of sanctions to impose for discovery. And it went on to note that while the trial court could have imposed a sanction that precluded the comparative negligence defense, it did not. And the Supreme Court of Florida held, quote, while the trial judge could have taken the action sought by appellant in this case, he chose instead to impose a less stringent sanction. It was his judgment as to what punishment should be imposed for the discovery failure. In the absence of an abuse of discretion, the sanctions imposed by the trial court should stand. And it sent the case back down. That's exactly what should happen here. The trial court is the one who imposed the default judgment. The trial court knows what it meant when it imposed that judgment. It knows the scope of what it was intending to do. And the trial court very clearly said twice, I was not intending to prevent Lennox from relying on the consequential damages bar. And in fact, the default judgment says that when it talks about the fact that we are still allowed to discuss and raise issues about what damages the appellant is entitled to receive. Now, while we spend a lot of time, while on that issue alone, I think that the order should be affirmed, a lot of time has been spent discussing whether a consequential damages bar is an affirmative defense. So I want to quickly talk about that now. To discuss that issue, let's start with the definition of an affirmative defense. And I'm going to use the definition in State v. Cohen because that's the case that the appellant relies on. An affirmative defense is any defense that assumes the complaint or charges to be correct, but raises other facts that, if true, would establish either a right to engage in the conduct in question or a valid excuse. It goes on to say, quote, an affirmative defense says, yes, I did it, but I had a good reason. That's never been Lennox's position. Lennox has never said we have the right to make defective HVAC systems, or that, yes, we make defective HVAC systems, but we have a good reason to do it. We've challenged liability. We challenged it on day one. We dispute that we have liability today. We simply lost that issue. Just like you can lose that issue at summary judgment or you can lose it at trial, we lost it on a default judgment. It doesn't mean that we concede liability. It simply means that we lost the issue. So therefore, it doesn't fit in within the definition of an affirmative defense. And cases have supported Lennox's position on this. In fact, the only Florida cases to address this issue have supported Lennox's position. First, there's the Cessna case, which we filed as supplemental authority a couple days ago. That case squarely addressed the question of whether or not a contractual consequential damages bar is an affirmative defense. And it says, quote, we disagree.
Counsel, if I may, just real
Yes.
quickly. Your notice of supplemental authority, we received it yesterday. Did
Okay.
you say you filed it 2 days ago?
It may have been yesterday. I'm sorry.
Okay. So do you think it's appropriate to file a case from the 1980s as supplemental authority less than 24 hours before your scheduled oral argument?
So it was 2008, which still makes it not new.
2008.
I just wanted to make the record
A
clear.
case
But
that's almost
your
20
point is
years
still
old.
well taken. It's not new.
Yeah. Yeah.
And the answer is, to be completely candid with the court, we have spent probably dozens of hours looking around, but for whatever reason, we didn't locate this case until literally this week when I went to update to make sure there are no new cases on this point. And for whatever reason, this case popped up when we hadn't seen it before.
Okay.
And counsel, as to the substance of those cases that you're talking about, the Florida cases, how do you respond to opposing counsel's point that those were contract cases where the contract is part of the complaint?
So
And
there's
in
a
this case, it seems a little distinguishable.
Well, I think there's a couple of answers to that. First of all, that argument wasn't raised below. And to Judge Smith's point, nearly everything that was argued today was not raised below. And in fact, most of it wasn't even raised on this appeal. So, for example, all the discussion about us not suing for express warranty, I didn't see that in their appellate brief either. And it certainly wasn't raised in the arguments below, and therefore it's been waived. But there's a couple key points here. So to answer your question, the trial court found that the warranty applies to plaintiff's equipment. That's in its summary judgment order. That finding of fact has not been appealed, therefore it is law of the case. That warranty says it precludes consequential damages, and it is not limited. It doesn't say it precludes consequential damages only for contract claims. It covers all claims of any kind. So that, for that reason, the cases that they cite simply aren't relevant. The contract on its own terms precludes it no matter what the claim is. And there are cases we cite in our brief that say that. And I should point out again, they never raised this issue before today anyway. But going back to the issue about the affirmative defense, and I won't belabor the point, but the Cessna case and the Tri-Lady case very clearly say that a contractual consequential damages bar is not an affirmative defense. The only distinction that they raise is the one that Your Honor just mentioned, and they also say the Tri-Lady is a federal court case, but Tri-Lady was a federal court case where the court was sitting in diversity, and under the 11th Circuit opinion in Proctor cited in our brief, in diversity actions, the federal court looks to state law to inform the determination of whether a defense is an affirmative defense. And regardless, as set forth in the Martin v. Airlines case, also cited in our brief, the Florida Court of DCAs have repeatedly said that Federal Rule 8C is the counterpart of the Florida Rule of Civil Procedure 1-110, and for that reason, federal court cases are persuasive. But beyond that, we didn't just cite those Florida cases, which are the only Florida cases on this issue. We cited literally dozens of cases nationwide. And to briefly respond to something that Appellant's counsel said, we didn't just cite Tri-Lady in passing a summary judgment. We argued it on over a page in our initial brief, and on page 5 of our reply brief, we cited, I think, close to a dozen cases on this issue. They just didn't respond to it. What they did down below is argue nothing more than we've been sanctioned, and they let all the other arguments go, which is why you can't find it in their brief. Now, not only did we cite 2 cases nationwide that say a consequential damages bar is not an affirmative defense, we also cited 2 cases that are directly on point with this one, where a party had a default judgment entered against it. It raised a consequential damages bar at the damages phase, and it was allowed to do so. That includes the Island Robots of Florida case that we cited in our brief, as well as McPherson. And I should also point out in the Harless v. Kuhn case I mentioned earlier, that was a default judgment where comparative negligence is an affirmative defense, and they were still allowed to raise it at the damages phase.
Counsel, speaking, I know you were saying about what your opposing counsel didn't raise in the lower court on appeal. I see that you cite the Harless case a single time in your appellate brief. Is there another time that I'm missing it? Is the table of contents not accurate?
We
I see it on
cited, I
page
believe,
31, second.
I believe
paragraph.
we cited it on page 31. That's correct, Your Honor.
And in page 31, it's part of a string cite to the following sentence. It is settled in Florida and nationwide that a default judgment establishes only liability and not damages. That's the sentence, and then you cite several cases in a string cite. And in Harless, you put as your parenthetical, a defaulted party has the right to contest damages caused by his wrong. The very argument that you just raised before the court about how a trial court has the ability to modify their sanctions order, that's not at all mentioned in your brief. So how is it appropriate for you to do exactly what you're saying your opposing counsel shouldn't be allowed to do, raise an argument that's not in your brief?
So we raised the issue of that the core issue on appeal is the interpretation and scope of the sanctions order repeatedly throughout our brief, and to help guide you on that, on page 42 of our appellate brief, or our response brief, we write, quote, Wentz's argument is effectively claiming that the trial court misunderstood the scope of its own sanctions order. Of course, the trial court is best suited to know the scope of its own sanction order, and we cited several cases. On page 3 of that brief, we wrote, on appeal, Wentz contends that the trial court misunderstood the scope of its own discovery sanction by permitting Lennox to assert the consequential damages bar. I can go on one more example. On page 19, we wrote, the trial court is in the best position to know the scope of its own order. I will also note in the reply and the support of cross appeal, we wrote about this extensively on page 12. And then let's not forget.
Well, wouldn't you think that if the Florida Supreme Court case that you came in here arguing right out of the gates was your winning case, that maybe you should have explained that in your brief rather than burying it in a string site and then relying on other DCA cases?
I think that the argument of that the trial court who wrote a sanctions order is in the best position to interpret its own order is largely self-evident. So that's why we spent less time discussing that in our brief as opposed to responding to the many different arguments that were made about whether or not a consequential damages bar is an affirmative defense. We think it's almost such an obvious point that we didn't belabor it. And I will point out, for what it's worth, on page 2 of the appellant's reply brief, they wrote that the core issue on appeal is the interpretation of the court's order. So there's really no dispute between the parties on that. Both sides have acknowledged that. We're just trying to figure out what the trial court was intending to do through the default judgment. And fortunately, it answered that question for us.
Counsel, I had raised this significantly with your opposing counsel about preservation. What I see, at least, as a potential preservation issue here, about even the arguments that are raised in relation to this limitation of liability provision being an affirmative defense, and looking at the response that the Dr. Wentz filed in relation to your summary judgment motion, and frankly, just not really seeing this argument really effectively being made. I want to hear your thoughts on whether this core issue of the affirmative defense argument, whether you feel it was even properly raised in the lower court and why.
We do not, and we expressly argue in our brief on appeal that these issues have been waived because they weren't raised below. For whatever reason, and maybe because they understand the law the way we do, the appellant focused their response to our motion for summary judgment on the sanctions order and really just discussing at length all the facts that it claims happened earlier on. They're really not arguing the law at all. So I don't believe that any of this is there, and that's why we expressly raised repeatedly in our initial brief that all these arguments have been waived. And again, frankly, a lot of what I heard today, I heard it for the first time. It wasn't even in their appellate brief, including a lot of the issues about whether they sued for a contract or express warranty or applied warranty. None of that's even in their appellate brief. Their appellate brief focused on the affirmative defense issue, which they didn't raise below. So they kind of got waiver on top of waiver at this point. And just to finish out the thought on the affirmative defenses, I just want to quickly point out that the cases that the appellant did cite in their brief are easily distinguishable. So they cite the Carol Lee case, which is out in New Jersey. But in that case, the court actually allowed the consequential damages waiver. It just found the damages were direct, not consequential. Craddock and Ingram are both out of the Fifth Circuit. But in both of those cases, the argument wasn't even raised. In Craddock, the court wrote, quote, the appellant failed to raise this argument in the court below, which is similar to what happened here. In Ingram, the issue wasn't even raised till after trial. And what was actually interesting in Ingram is the court said, even if it was an affirmative defense and it should have been raised, the defendant could still raise it during the case as long as they did it before trial and didn't cause prejudice. And that's certainly the case here. It's just a contractual term. So there's no, one of the things that they didn't argue down below is that they needed to know about this defense so they could do something about it. There's a mention now in the appellate court that was waived below about notice. But first of all, notice only applies to affirmative defenses, and this isn't one. And the notice issue doesn't matter here because they had brought implied warranty claims. They knew they were subject by the warranty. They made an actual warranty claim on a different part and got the benefit of it. Once they got it, they could have done discovery if they thought there was some discovery they need, though they never say what it was. But they sat on their hands for 5 months and then didn't even raise any issues about it at summary judgment. So those arguments don't apply. So what that leaves them with is a 1982 case from Florida, from New York, and nothing else. And certainly that doesn't come over or surpass the Florida cases that we cited and the dozens of other cases we cited, none of which matter because at the end of the day, the judge is the one who should determine the scope of his sanctions. And on that, I do want to follow up on something I heard Judge Smith say in the argument right before this one, which is that the sanction should relate to the conduct. And the alleged conduct at issue here is that Lennox didn't produce some data that the appellant claims they need in order to prove liability. Well, the sanction that was issued deals with the conduct. It established liability. It has nothing to do with damages, which is why the trial court said we still have to have an issue on what damages you're entitled to receive and why we're allowed to raise the damages defense. I have 1 minute left, so I just want to very quickly address the cross appeal. On the cross appeal, what we are asking to do is, in the event that this case goes forward, we don't think that it should, our motion for leave to file a cross claim against the original defendant, conditioned heir, should be granted. We sought leave before summary judgment was argued and at least 5 months before there was a scheduled trial. The court should freely give leave, and it was required to look at 3 items: whether there was prejudice, whether we abused your right to amend, and futility. If you look at the trial court's order, it doesn't address any of those factors. And for that reason alone, it should be reversed. What the court said is that it was untimely, but this court, for the reasons we put in our brief, has held that untimeliness is not enough. You have to show actual prejudice. No showing of prejudice was made and no finding of prejudice was made. So for that reason and the reasons set forth in our brief, we believe that if the case goes forward, that ruling should be reversed. I have to answer any questions you may have.
Thank you.
Thank you.
May it please the court, as to the preservation issue, take yourself back in time to the trial court. The trial court enters a sanctions order, establishes liability on causes of action, none of which are for breach of the express warranty, none of which reference the warranty. There's affirmative defenses. The affirmative defenses say, can't sue me for negligence because there's some exclusion out there somewhere they don't attach to. Can't sue me for these other things because I've got an exclusion, I've got a waiver, or I've limited damages. Motion for summary judgment post-sanction is filed. The motion for summary judgment says they don't have any damages because I have this limitation. You then go to Dr. Wenz's response. Dr. Wenz's response is, there's a very clear order where you had addressed these things. You called them an affirmative defense. The court agreed they're an affirmative defense. The court struck them. We say, you're not allowed to raise them anymore. Then we say, even now that you've shown us this alleged warranty, the warranty doesn't get rid of negligence claims. It would still be unconscionable when we go through things.
Counsel,
Yes.
isn't that all focused on the scope of the sanctions order?
It is focused on the scope of the sanctions order, and we're going to the same place. So let's go to the next stop. So they file their response. They file their motion. We file a response. You read our response, talks about affirmative defenses, talks about whether they apply, don't apply. We also say we have direct damages. Then we go to the court's order, and the court says, boy, Florida enforces limitation of damages all the time. And he says, I cannot strike them, is basically what he says. He is wrong on that law. This whole issue of his discretion in the order itself to do what he did in terms of the sanction order and the default judgment, that was not briefed by the other side of the trial court, and the trial court did not bring that up anywhere until he issues the order. So when we're up here on appeal,
How do we
and they
know
want
that without a transcript? We're just taking your word for it?
cold briefs, there's no issue could have been raised factually or introduced any evidence. The actual record itself is very clear that nobody briefed and nobody cited any cases regarding the court didn't have the discretion to do what he did.
But counsel, we don't know what was argued at the actual hearing. And even if it's not in the pleadings or the motions before that hearing was held, it could have been argued by consent, and we don't have a transcript.
The record that this court does have is you have an unappealed default judgment that specifically references these defenses and specifically says they cannot be raised. The court has crystal clear affidavit showing direct damages of far in excess of $100,000. You have a court saying there was no evidence before me of direct damages, and we know that that is steadfastly not true. The cold record, crystal clear, there are direct damages. He says apparently there's none. Crystal clear affidavit. We have crystal clear claims that are not brought under the express warranty. We have crystal clear negligence claim. Even the Cessna case cited to the court yesterday, if we read it, the negligence count, the court in that case, the Second District Court of Appeal, did not apply the limitations of damages provision there. Very clear in our record before this court, we argued specifically that you couldn't apply it to the negligence claim anyway.
Counsel, they, in their motion for summary judgment, they cite the Tri-Lady case. They cite specifically that in the Tri-Lady case that the defendant's limitation of liability defense was not an affirmative defense. So they're making the argument, they're citing a case that supports that argument. And from a preservation perspective, you say, look at the cold briefs. In your response to Lennox's motion for summary judgment, other than just saying you're wrong, it really is an affirmative defense. Did you cite any cases? Did you make any argument that it was in fact an affirmative defense? Explain to the trial court, here's why. Here's Black's law that says with an affirmative defense. Here's why you're wrong, Lennox, and trial court, why they're wrong. Did you do anything other than just say, well, no, it's not an affirmative. No, it is an affirmative defense.
We crystal clear pointed out that we did not sue for express warranty and that the Tri-Lady case is an express warranty case. We didn't sue for express warranty. It's not similar in any way. That's not what we sued for. In Tri-Lady, they literally sued for the installation of the chiller. They literally sued saying, here's our express contract. They had judicial admissions that that was the case. And then they tried to argue it was waived by the installation company because they should have brought it as an affirmative defense. And the Southern District of Florida said, well, you sued for it, you attached it, there's judicial admissions. It's the same contract that you're suing under. We're not even going to let you distance it and try to make an oral argument or a claim for an oral contract.
Okay. And you said you told the trial court that about the Tri-Lady case?
No, we told the court that we didn't sue for express warranty. We only sued for the negligence implied. That's not what we sued for.
Did you discuss the Tri-Lady case at all in your response to their summary judgment motion?
I don't believe it is expressly dealt with in our response, and that's because that's not what we sued for. And we keep saying, they keep trying to misrepresent what we're suing for. They keep saying that we're saying we had a broken part and we're suing over the broken part. Very clearly in our response, we say that's not the claim. That's not what our affidavit show. That's not what our complaint shows. That's not what we sued for.
Thank you, counsel.
Thank you.
Court's in recess.